The Supreme Court just issued a 9-0 ruling, and I am going to make a statement that I stand behind completely. This is the most important constitutional decision affecting American homeowners and gun owners in the last decade, and the Department of Justice has done everything in its power to keep it quiet. 9 justices, 0 disagreement, in a court so ideologically divided that they regularly split 5-4 on what the Constitution means. Every single one of them, from the most conservative to the most liberal, looked at the same set of facts and said the same thing. What the government did was unconstitutional. What law enforcement had been doing for decades was unconstitutional. And what they had been getting away with in living rooms and kitchens across this country, walking into people's homes without a warrant and walking back out with their legally owned firearms, that is unconstitutional too. This is not a partisan ruling. Let me be absolutely clear about that from the start, because what I'm about to tell you is going to make you angry. And I want that anger directed at the right target. This is not about Republicans or Democrats. This is not about one administration or another. This is about a legal doctrine that law enforcement agencies have been quietly exploiting for nearly 50 years to bypass the most fundamental protection the Constitution gives you, your home. And it is about one ordinary man in Rhode Island who refused to accept what happened to him, hired a lawyer, and took his case all the way to the highest court in the land. Because of what he did, because of the fight he was willing to have, every American who owns a firearm, every American who keeps anything of value inside their home, every American who believes the government should have to ask a judge before walking through your front door is better protected today than they were before. If you own a gun, you need to understand this ruling completely. If you have family members who own firearms, you need to share this with them. If you believe in the Fourth Amendment, not as an abstract concept, but as a real, living, enforceable guarantee, then the next several minutes are going to give you something genuinely important. Because knowledge is the only thing that turns a right from a word on paper into a protection you can actually use. Let me tell you exactly what happened, because the story itself matters. It started not with a conspiracy or a government overreach operation or some calculated policy decision. It started with a married couple having a very bad night. His name is Edward Caniglia. He lived in Cranston, Rhode Island with his wife, and by every measure he was a completely ordinary man. One evening, the two of them got into a serious argument. The kind of argument that marriages sometimes produce, heated, emotional, words said that shouldn't be said. And in the middle of that argument, Edward did something dramatic and foolish. He grabbed one of his handguns, placed it on the kitchen table, and said to his wife, "Shoot me now and get it over with." It was a moment of emotional crisis, not a threat to his wife, not an act of violence. Nobody was hurt, nobody was in danger. The gun sat on the table and the argument eventually wound down. But his wife was frightened enough by the moment that she left the house that night to stay somewhere else, and the following morning she called the police. When officers arrived and spoke with Edward, he was calm, he was cooperative, he was not acting erratically. The officers assessed the situation, spoke with him at length, and determined that they wanted him to undergo a voluntary psychiatric evaluation at the local hospital. Just to be safe, they said, just to make sure he was okay. And here is the part that matters enormously for what came next. They made him a promise. They told Edward directly, "Go to the hospital, cooperate with the evaluation, and when you come back, everything will be here waiting for you. Your home, your property, all of it, exactly as you left it." Edward Caniglia believed them. He thought he was doing the responsible thing, the cooperative thing, the thing that a reasonable citizen does when law enforcement asks him to get some help. He got into the ambulance and he went to the hospital. While Edward was sitting in that hospital room, doing exactly what the police had asked him to do, honoring the agreement he believed he had made with them, those same officers went back to his house. They walked inside. There was no warrant. There was no judge. There was no court order of any kind. Nobody had appeared before a magistrate and presented evidence. Nobody had demonstrated probable cause. They simply walked into a private home and began looking through it. They found Edward's firearms, and they took them just like that. Without permission, without a warrant, without any judicial oversight of any kind. They removed a man's legally owned property from his legally owned home while he was away cooperating with the very evaluation they had asked him to undergo. When Edward came back from the hospital, the evaluation found nothing wrong with him, no diagnosis, no danger, no reason he should not have his firearms returned. He asked for his guns back. The police said no, they could not return them. He had been told everything would be waiting for him. He had been given a direct promise by law enforcement officers. He had cooperated completely and in good faith, and in exchange for that cooperation, his property had been taken from his home without a warrant. He had been lied to. Now here is where the story shifts from infuriating to genuinely dangerous for every person in this country. Because when confronted about what they had done, the police officers did not deny it. They did not apologize. They did not express any uncertainty about whether they had the authority to do what they did. They had a name for it. They called it the community caretaking exception. And they were completely confident that it justified everything. The community caretaking exception has its origins in a 1973 Supreme Court case called Cady versus Dombrowski. In that case, the court was dealing with a situation involving a vehicle, specifically the question of whether police could search a car without a warrant when they were acting in a caretaking capacity rather than an investigative one. The example the court had in mind was something genuinely mundane: a car broken down on a highway, an abandoned vehicle blocking traffic, a situation where an officer needs to do something practical without the time or the need to go before a judge first. The court said that in those limited circumstances involving vehicles on public roads, officers could act without a warrant because they were functioning as community caretakers rather than as law enforcement agents conducting an investigation. That was the original limited vehicle-specific rule. What happened over the next 5 decades is something that should alarm every American who understands how rights erode. Police departments and their lawyers took that narrow vehicle exception and stretched it. They argued in court after court, in state after state, that if an officer could enter a car without a warrant based on caretaking concerns, then an officer could also enter a home without a warrant based on caretaking concerns. They said that if someone inside a house might be upset, might be a risk to themselves, might have a firearm that could become dangerous in their emotional state, then the community caretaking exception gave officers the authority to walk right in, no warrant required, and take whatever they believed posed a risk. The word caretaking did an enormous amount of work in this argument. It made the intrusion sound benevolent. It made the property seizure sound like a kindness. Temporary safekeeping, they called it sometimes, just looking out for you. And lower courts in multiple states accepted this argument. Gun owners had their firearms taken during mental health calls, during domestic disturbance calls, during neighbor complaint calls where someone who had never been inside a person's home called police to say they seemed a little off lately. There was no judge involved, no warrant was signed. No evidence was presented to any neutral authority. Just an officer making a personal judgment call and walking out of your home with your property. This went on for years quietly with almost no national attention until Edward Caniglia decided he wasn't going to accept it. He sued. He took the Cranston Police Department to court and argued that what they had done, entering his home and seizing his property without a warrant, violated his Fourth Amendment rights. Now, the Fourth Amendment is not complicated in its plain language. It protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And it says that no warrant shall be issued except upon probable cause supported by oath, describing the place to be searched and the things to be seized. In ordinary English, that means the government cannot come into your home and take your belongings without first convincing a judge that they have a good reason. That is the process. That is the requirement. And it is not optional. Edward's case made its way up through the courts, and on May 17, 2021, the Supreme Court of the United States issued its ruling in Caniglia versus Strom, 9-0. Justice Clarence Thomas wrote the majority opinion. He wrote it in clear, direct, unambiguous language, the kind of judicial writing that does not leave much room for creative reinterpretation. The community caretaking exception, the court said, does not apply to the home, period. The court went back to the foundational history of the Fourth Amendment, back beyond the Constitution itself to the English common law principles that the founders were encoding when they wrote it, and it reaffirmed what has always been the central principle of privacy law in the Anglo-American tradition. The home is different. It is not a car on a public road. It is not a vehicle in a parking lot. It has never been treated the same way under the law, and there is no legitimate basis for beginning to treat it that way now. The court said explicitly that officers cannot invent new exceptions to the warrant requirement simply because doing so would be more convenient or more efficient. The Fourth Amendment was written precisely to prevent that kind of reasoning. 9-0. That is as decisive as the Supreme Court gets. So what does this actually mean for you in your home, in your life today? If police show up at your door because a neighbor called in a concern, because a family member mentioned you seemed stressed, because someone reported that you had an argument, they cannot walk inside and take your firearms. Not under the community caretaking exception, not under the banner of temporary safekeeping, not because they think you might be having a hard time and they want to look out for you. Even if their intentions are genuinely good, good intentions do not override the Constitution of the United States. You have the right to stand at your door and tell officers politely but firmly that you do not consent to any search of your home. You have the right to say that if they believe they have a legal basis to enter, they are welcome to go before a judge, present their evidence, and obtain a warrant. and you have the right to do all of that without being penalized for it, because exercising a constitutional right is not obstruction, it is not resistance, it is exactly what the Constitution was designed to allow you to do. But I need to address several things directly because there is a significant amount of misinformation spreading about this ruling. And if you believe the wrong version of what this case means, you could find yourself in serious trouble. The first misunderstanding I hear constantly is that this ruling means police can never enter your home without a warrant under any circumstances whatsoever. That is not what the ruling says, and it is not the law. There are still recognized exceptions to the warrant requirement, and they still apply. If there is a genuine, immediate, life-threatening emergency inside your home, if someone is actively being harmed right now, if there is a hostage situation unfolding, if there is a person in imminent physical danger, police can still enter without a warrant to address that immediate threat. The exigent circumstances exception exists. The hot pursuit exception exists. If an officer is chasing a fleeing suspect and that suspect runs into your home, they do not need to stop and wait for a warrant. These are real and legitimate exceptions with long legal histories. What Caniglia eliminated is the fake emergency, the manufactured concern, the wellness check that conveniently ends with a property seizure, the vague sense that someone might be upset and therefore their home is fair game. That category of excuse is gone. The court has said it clearly. But genuine, immediate life or death emergencies are a different matter and always have been. The second misunderstanding involves people who had property taken under this doctrine before the ruling was issued. There is a belief circulating that if your guns were seized under the community caretaking exception prior to May 2021, this ruling automatically returns them to you. That is not how precedent works. The ruling absolutely creates the legal foundation you need to challenge what was done. It gives you powerful, unanimous Supreme Court authority to argue that the seizure was unconstitutional. It reopens the door that was previously closed, but it does not reach back in time and automatically undo what happened. You have to take action. You have to file in the correct court, in the correct jurisdiction, within applicable time limits, with the correct legal arguments. This requires an attorney who understands the specific laws of your state and the procedural requirements of the relevant courts. The ruling is the weapon. You still have to pick it up and use it. The third misunderstanding, and this one matters enormously for practical purposes, is that the Fourth Amendment protects you equally everywhere. It does not. Your home sits at the absolute top of the constitutional protection hierarchy, and Caniglia reaffirmed that in the strongest possible terms. Your vehicle, which is what the original community caretaking exception was about, receives substantially less protection. Courts have long held that you have a reduced expectation of privacy in your car compared to your home, and that has not changed. A public space, a sidewalk, a parking lot, a common area receives even less protection than your car. The concentric circles of constitutional protection are real, and they matter. The court's ruling in Caniglia reinforces that the home occupies its own special category, the most protected space in American constitutional law, and that the government cannot blur that line by importing vehicle rules into the domestic sphere. Now let me connect this to the larger constitutional framework, because this ruling does not exist in isolation. It is part of a series of Supreme Court decisions that have, over the past 2 decades, built something that looks increasingly like a comprehensive wall of protection around the rights of American gun owners and homeowners. And understanding how these cases fit together makes each one more powerful, not less. In 2008, the Supreme Court decided District of Columbia versus Heller. That case established for the first time as a matter of binding Supreme Court precedent that the Second Amendment protects an individual right to keep and bear arms. Not a collective right, not a right tied to military service, an individual right belonging to each person to keep firearms in their home for self-defense. This was a landmark decision, and it was also contested, decided 5-4. 2 years later, in 2010, the court decided McDonald versus City of Chicago, which extended the Heller ruling to apply not just to federal law, but to state and local governments as well. Before McDonald, some states and cities argued that Heller only restricted federal action. McDonald shut that argument down. The Second Amendment applies everywhere in the country, at every level of government. Then in 2022, the court decided New York State Rifle and Pistol Association versus Bruin, and it changed the legal standard for evaluating gun regulations in a way that has had enormous downstream effects. The Bruin decision said that for a firearms regulation to be constitutional, the government must demonstrate that it is consistent with the historical tradition of firearm regulation in America at the time the Second and 14th Amendments were adopted. In plain language, if the government wants to restrict your access to firearms, they have to find a historical analog, an actual law from the founding era, or shortly after that, supports what they're trying to do today. If they can't find one, the restriction is unconstitutional. That standard has already led to the striking down of numerous gun regulations at the federal and state level, and its full impact is still being felt through the courts. And then there is Caniglia, which sits in this framework as the Fourth Amendment counterpart to the Second Amendment protections of Heller, McDonald, and Bruen. Because what good is the right to own a firearm if law enforcement can simply walk into your home and take it away without going before a judge? Heller protects your right to own. McDonald makes it nationwide. Bruen says the government needs deep historical justification for any restriction on that right. And Caniglia says the government cannot create informal workarounds, cannot invent extrajudicial mechanisms, cannot use vague welfare concerns as a pretext to strip you of your property without due process. These four cases form something genuinely coherent. They protect you at the point of acquisition, at the point of regulation, and at the point where the government might try to take what is yours. Every American who cares about these rights needs to know all four case names, not just one, all four, and what each one actually held. There is a broader principle underneath all of this that I think deserves to be stated plainly, because it is the principle that connects the legal doctrine to your daily life. Rights do not disappear suddenly. They do not vanish overnight in a single dramatic act. They erode slowly through 100 small exceptions and 1,000 quiet workarounds, each one sounding reasonable in isolation, each one justified with language that sounds like common sense. Community caretaking sounded reasonable. Temporary safekeeping sounds reasonable. Wellness check sounds caring and benign. But each of these phrases was functioning as a vehicle for something much more significant: the gradual erosion of the requirement that the government obtain judicial authorization before entering your home and taking your property. The community caretaking exception applied to homes was not a minor procedural shortcut. It was a hole in the Fourth Amendment large enough to drive a truck through. And police departments across the country were driving that truck on a regular basis. What stops this kind of erosion is not trust in institutions, though that can be valuable. It is not goodwill toward law enforcement, though most officers are not acting with bad intent. What stops it is citizens who know the law, citizens who know the case names, citizens who understand exactly what the court held and exactly what rights they have as a result. Because when you know Caniglia versus Strom, when you know the vote was 9-0, when you know that Justice Clarence Thomas wrote the opinion and every member of the court agreed, you are no longer relying on an officer's goodwill or a department's policy. You are standing on constitutional bedrock. You are standing on something that the highest court in this country unanimously affirmed. That changes what you can say at your door, what you can assert in a conversation with law enforcement, and what you can argue in court if it ever comes to that. So let me leave you with the three things that matter most. The case name is Caniglia versus Strom. The date is May 17, 2021. The vote is 9-0. Memorize those three facts. They are the foundation of everything else. The principle is that your home requires a warrant, not a neighbor's phone call, not a family member's concern, not an officer's personal assessment that you seem like you might be having a rough time. A warrant signed by a judge based on evidence describing what they are looking for and why they have reason to believe they will find it. That is the process, and the Supreme Court has told every law enforcement agency in America that they cannot skip it. And the final thing, the most important thing, is that knowledge is the mechanism by which rights are preserved. Edward Caniglia knew enough to understand that what happened to him was wrong. He was willing to fight. He fought all the way to the Supreme Court, and he won unanimously. His willingness to assert his rights, to refuse to accept what had been done to him, produced a ruling that now protects every homeowner and every gun owner in the United States. What is det lukken nu skjer så de er farlig til think the hive and kles dufton the farlig to think the hive in Newark South. His igjen farlig to think the hive in Newark South. And that is what one person with knowledge and determination can accomplish. Share this, make sure the people you care about understand what the court actually said. Because the DOJ is certainly not going to send them a letter about it.